Hello, in this video we're going to be discussing the Vienna Convention on the Law of Treaties. I will be referring to a PDF scan of the actual treaty itself, which I have posted here. This is on Moodle, but it'll be the same on Canvas once we're using Canvas. Right here I have a PDF, the Vienna Convention on the Law of Treaties. So I want you to reference that as we're going to go through in this lecture, and we'll take a look at some of the specifics on the Vienna Convention. So I'm going to switch over to my document camera so we can take a look at the treaty itself. Okay, this is a PDF of the Vienna Convention on the Law of Treaties. So first of all, a little bit of background about the Vienna Convention and why it's so important. We have talked about the idea of customary international law in other videos and other materials for the course. Just as a reminder, customary international law basically is this area of law that is developed through the conduct of sovereign states. It's kind of like the idea of see what I do and not what I say, or actions speak louder than words. That is very much customary international law. Historically, customary international law was one of the primary sources of law, and that's still true today, although to less of a degree, due to codification of these customary rules into the form of a treaty or conventions, which lead to written international law. So the Vienna Convention is important because essentially it is the codification. Remember, codification means to put down into writing written law, basically, in the form of a convention, which is a large treaty, that essentially takes a number of the customary rules of international law and puts them into writing. Now, as we've talked about under the International Court of Justice, Article 38, customary international law is second to a convention. Under Article 38, remember, a convention is the primary source, or a treaty, primary source of international law. Then comes customary international law. So the idea over time is customary rules have been put into the form of a written treaty or convention, and that is where the Vienna Convention essentially codifies these customary rules. So the Vienna Convention came into force, was first done in Vienna in 1969, entered into force in 1980 by the time it was finalized, and it is a laundry list of customary international law rules that we've seen put into writing. So let's just go through some of the provisions of it that I want you to know about. So first of all, let me blow this up so you can read it easier. So first of all, the Vienna Convention under Article 2 Article 2 provides that a treaty means an international agreement concluded between states. And I'm going to highlight this, written form, governed by international law. So, under the Vienna Convention, a treaty must be in writing. In other words, the old verbal treaties among sovereigns, kings, rulers, monarchs, whatever, would not be considered a formal treaty under the Vienna Convention rules. So a treaty must be in writing under the Vienna Convention. If it's not in writing, it doesn't constitute a treaty for purpose of the Vienna Convention. Next we have these terms: ratification, acceptance, approval, and accession. So these are terms that refer to joining onto a treaty either at the very beginning as an original signatory state of the treaty, or later on joining on to the treaty by accession. So ratification basically is the term that refers to what is required under the domestic law of that state in order for a treaty to be legally binding. Here in the United States, the President has the power to conclude treaties, but then it's sent to the Senate for their advice and consent, which basically requires the Senate to approve treaties. That's a form of a check and a balance under our Constitution. Other countries have different methods of ratification depending on that country's particular law. I want you to know the word accession right here. The word accession refers to joining on to a treaty or a convention after it's already in place. So you're basically, you weren't one of the original members of the treaty, but you join on, you accede, or you agree to the treaty at a later date. And later on it talks about ways that that can be done, which is beyond the scope of this class. All right, let's go down here to the next term I want you to be familiar with, right here, and that's the term reservation. Okay, a reservation means a unilateral statement, however phrased or named, when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or modify the legal effect. Now, in plain English, the term reservation basically is when a country joins on to a treaty, there may be part of the treaty that they don't agree with. And if that's the case, they will issue a reservation. So they may say, we agree with paragraph 1 through 100 of the treaty, but we don't agree with paragraph 47. And therefore we will reserve and not agree or be part of paragraph 47, but all of the other provisions of the treaty we will agree to. Now sometimes reservations are acceptable, other times reservations are not valid. In other words, if you try as a country, you want to join on to a treaty, and you try to reserve out of a particular portion of the treaty, that may not be valid under international law, and are not considered part of the treaty. Later on, the Vienna Convention goes into detail about when that, some of the rules there. We'll look at some of those, but it gets beyond the scope of this class. Okay. All right, Article 6, or Part 2, Section 1, Article 6. Capacity of states to conclude treaties. Now I highlight this because this is, again, codification of customary international law. Every state possesses capacity to conclude treaties. Now the reason why that phrase is important is, first of all, it's saying a state is the authority, a state has the authority to make treaties. So when we talk about statehood in a different lecture, what constitutes a sovereign state, what are the requirements under the Montevideo rules, which we'll talk about later, what is a formal state. If you're considered to be a formal state, then you have the ability as a state to enter into treaties. Now let's flip that around. That also means that when you're looking at whether or not a geographical area is in fact a sovereign state under international law purposes, one of the ways you look at whether or not it's recognized as a state is whether or not it has entered into treaties. And that's evidence if that state has entered into treaties with other recognized states that it is in fact a sovereign state recognized under international law. Okay, Article 18. Obligation not to defeat the object and purpose of a treaty prior to its entry into force. I point this out. This is also a codification of the idea of customary international law. And this is basically the idea that if a state enters into a treaty or is negotiating for a treaty or a convention, as part of the good faith requirements of the state, prior to ratification under that internal law of that state, they're in essence bound in good faith to not defeat the purpose of the treaty. So this would be, for example, maritime navigational rules, a treaty on maritime mining or ocean mining. So treaties are being discussed. They're not yet ratified by the Senate, but during that time a state has a good faith obligation to follow through on the overall purpose and object of the treaty. Now this gets to be a gray area. The reason this is important is it can create a form of customary international law, even though the treaty hasn't been fully ratified. So let's move on a little bit here. Okay, Article 19, formulation of reservations. As we talked about earlier, a reservation is when a state decides part of the treaty they don't like and they don't want to be part of that particular paragraph or section of a treaty. So, when is that reservation invalid? Number one, if the reservation is expressly prohibited by the treaty or convention itself. So this is the idea that the treaty says if you're going to join on to the treaty, either at the beginning or accede later on and join later on in the future, you have to agree to all of the treaty or none of it. You can't say we agree to this part but not that part. You have to agree to all of it. The other time that I want you to know about is if a reservation, even if a treaty allows for reservations of part of the treaty, if reserving or excluding the part of the treaty that's the fundamental purpose of the treaty, that defeats the purpose of the treaty to begin with. So let's say it's an environmental treaty, and the idea is to cut down on emissions, and the emission standards are set in the treaty itself. Maybe how many parts per million of a particulate in diesel or whatever. And a state joins on to the treaty, but they say, we don't agree with paragraph that sets the parameters of carbon particulates. Well, that defeats the whole purpose of the treaty, so that reservation would not be valid. Now, I'm not going to go into that much detail in this course about reservations. I just want you to know what is a reservation, and then these two times when a reservation would not be valid. While I'm on that subject, when you're taking the midterm or doing a quiz, have this Vienna Convention, it's in our materials, have that available so you can look things up, because I do refer to specific articles in my test questions, and you're going to want to be able to look those up as you're taking the quiz or the test so you can look up and get the right answer. All right. Okay, Article 26. We've talked about this term before. Pacta sunt servanda. Pacta, or pact, or agreement. Sunt is should. It's a Latin form of should. Servanda, be served. In other words, you, as a state signing on to a treaty, have a good faith obligation to fulfill the terms of the treaty and not to take action that in bad faith would violate the terms of the treaty. This is a form of customary international law. Again, it's codified. Basically, it means that if you're going to agree to a treaty or a convention, you have a good faith obligation to fulfill those terms and not basically do things behind the scenes that would violate the terms of the treaty. All right, let's move over to Article 34. Okay, treaties and third states. A third state is a state that is not part of the convention or the treaty. So they're not theoretically bound by it. Article 34, a treaty does not create either obligations or rights for a third state without its consent. Now, what that's basically saying in plain English is that if a state is not part of a treaty, they're not bound by it, nor can they take advantage of the terms of the treaty as a benefit. So if you want to be part of a treaty and benefit from it, you have to ratify, you have to sign on at the beginning as a signator or accede to the treaty later on in order to take advantage. Now, the opposite of that is if a treaty covers a subject and a state is not part of that treaty, this basically is saying it creates no obligation for that state. And that makes sense, right? If a state has not joined on to a treaty, it shouldn't be bound by the requirements that are created or the law that's created by the treaty itself. Just like if I wasn't part of a contract, I can't take advantage of it, nor am I bound by it under domestic law. Now, I want you to think about that for a minute, because this is where it gets a little interesting under the Vienna Convention and also under the rules of the International Court of Justice under Article 38. So Article 38. Okay, I'm going to put a little star by this Article 38. This is Article 38 of the Vienna Convention. Now, there are two Article 38s that we are discussing in this class. The first is Article 38 of the International Court of Justice, the ICJ. We've talked about that in other videos and PowerPoint slides. That establishes the hierarchy of international law, the primary being conventions and treaties, then customs, and on down the line. Article 38 here of the Vienna Convention is a bit interesting because it, in some ways, doesn't really match up with Article 38 of the International Court of Justice. So let's just look through it. Nothing in Article 34 and 37 precludes a rule set forth in a treaty from becoming binding upon a third state as a customary rule of international law recognized as such. Now, what does that mean? That basically means, remember Article 34, which we just looked at, says that a state is not bound by a treaty unless it is part of a treaty. However, this Article 38 goes on to say, behind the scenes here, that a treaty, even if a state's not part of it, can still, in effect, bind the non-party state if it's a customary rule of international law. So, if you think about that a little bit, that in essence is saying that customary international law can still be of a higher value than a treaty, which sort of conflicts with Article 38 of the International Court of Justice that says that treaties and conventions are the highest form and customary is second. Now, where does that come from? Well, let me show you another article here. Okay, this is Article 53 of the Vienna Convention. Treaties conflicting with a peremptory norm of general international law. Jus cogens. We've talked about that in other slides, but here it is in writing in the form of the Vienna Convention, codification of probably the most important rule of international law, a peremptory norm. So, a treaty is void if at the time of its conclusion it conflicts with a peremptory norm of general international law. And later on it goes on to say if a peremptory norm, a new peremptory norm comes into place, it has the ability to override a conflicting treaty. But it's all the same idea. And here's the idea that the notion that I'm getting to. This puts into writing the idea that a peremptory norm of general international law, jus cogens, will always be the highest form of international law. Now remember, jus cogens, peremptory norm, are things like slavery, prohibition on slavery, genocide, torture, use of certain type of weapons, those type of things that we've discussed in other videos. But this is where we see this idea that under the Vienna Convention, preserved under Article 53 and under Article 38 of the Vienna Convention, the idea that, number one, a peremptory norm still remains the highest form of international law. A treaty that conflicts with that is void. So the treaty would override, peremptory norm would override the treaty. Now that in a bit conflicts with the International Court of Justice idea that a treaty is always the highest form and then custom. So in essence, they kind of are flipped a little bit. Now in some ways, that conflicts between Article 38 and Article 53 of the Vienna Convention and the provisions of the International Court of Justice. However, with that said, in other ways they don't conflict because, typically speaking, a peremptory norm of international law will also be codified in some other treaty, like a treaty that, under human rights law, international human rights law, that prohibits slavery, genocide, etc. So they conflict in some ways, they don't in others. This has been an area of debate and study in academia, international law. But essentially the point I want you to know is that the Vienna Convention codifies the idea that a peremptory norm is essentially the highest form of international law. Part 2 to that is, under Article 38 of the Vienna Convention, that means that even if a state is not part of a treaty, if the treaty deals with a peremptory norm, it can still be applied to a non-member state. So peremptory norm under the Vienna Convention remains the highest form of law. And that's basically codification of customary law. Okay, let's go over to Article 64. And again, I'm showing you this because this goes on in that same theme, that a peremptory norm of international law remains the highest form of law. If a new peremptory norm of general international law emerges, any existing treaty which is in conflict with that norm becomes void and terminates. So we have some new peremptory norm of international law that arises, perhaps in the area of international environmental law, or with COVID in the area of international pandemic response, or those type of things, or perhaps in the future with space, or whatever. You get the idea. So we have a new peremptory norm that has emerged. And within this peremptory norm, there are treaties that conflict with this new peremptory norm. Under Article 64, the peremptory norm would override a conflicting treaty, or the provisions of a treaty that conflict. So once again, back to the theme, a peremptory norm of general international law is essentially the highest form of international law, and that's codified in the Vienna Convention. Okay, now in terms of the Vienna Convention, I do have some other provisions that may appear in some of my quiz questions, and I'll refer to specific articles that deal with the same information. And so that's why when you're taking a quiz or the midterm, have the Vienna Convention available for you so that you can refer to the specific articles so you can get the answer correct. And I know it's a little bit confusing, but basically the takeaway that I want for you to get on the Vienna Convention is that the Vienna Convention is a codification of the law of treaties, which also is a codification of many of the customary rules of international law that we have, and it is right there in writing that essentially a peremptory norm, jus cogens, becomes the highest form of law, which could even override a treaty if it conflicts. Okay, that is going to be the end of this lecture on the Vienna Convention on the Law of Treaties.